Good morning again. At the conferences such as this, you often hear experience from Western countries, let's say, about the legal protection of whistleblowers, and you often wonder whether this could apply to Czech Republic or countries in Central Europe, and that's why this is very important panel discussion at this conference to try to find some best practices, experience and recommendations from the neighboring countries. When I say best practices, it should be in quotes because the experience or practice is still very fresh. In three of the 5 countries we are going to discuss, there are some kind of laws protecting whistleblowers, but they are as old as 2014 or 2015. So we'll have some first data, I believe, or some first learnings on how this works, but of course it's still very preliminary. Let me briefly introduce the speakers that you have also described in your conference leaflet. On the left, Vladimir Radomirovic, is an investigative journalist from Serbia and 2015 Nieman Fellow at the Harvard University. He co-founded Pišťalka NGO in Serbia, Pišťalka meaning of course whistle. And he's editor-in-chief of this website of the same name that became so powerful or influential that helped in pushing through legal protection for whistleblowers, a standalone law in Serbia. Next to him is the least known person at this panel and this conference, I believe. You all, I assume you all know Lenka Franková. I will only add that she's also one of the authors of a publication on whistleblowers about Us With Us that you have received at the entrance, and she also wrote the recommendations for a legislative proposal of complex whistleblower protection in the Czech Republic, and is a member of the working committee for whistleblowing at the Government Council. I would also like to introduce Anita Končík, who's from the K-Monitor, a non-profit, a leading Hungarian non-profit organization or think tank on corruption and good governance. She has been monitoring Hungarian legislative proposals on whistleblowing and also submitting comments to the government on and recommendations on such attempts. Anna Wojciechowska-Nowak is a legal expert, a lawyer, who assists whistleblowers in court trials and also is an author of blueprint of such legal protection or law on whistleblowers in Poland. I'm sorry, and I skipped Pavel Nechala, who's attorney at law and managing partner at a law firm, and he's been working with Transparency International, World Bank or OECD on legislative proposals and investigating the issue of whistleblowers. I will start with Pavel because the Slovakian government or parliament has recently enacted a bill on whistleblowers, a law on whistleblowers. If I believe it is valid since 1st January 2015.
It was approved in 2014, good morning, and came into effect on 1st January this year, but there are also provisions, especially obligations for business, which came into effectiveness only on 1st July this year. So really this legislation is fresh. If I can say a few words about how this regulation, how it regulates whistleblowing. As Richard described these models of legislation, I'm persuaded that this model the Slovak legislation is a structural model. We can find there provisions for protection of whistleblower against retaliation, but there are also provisions which creates new obligations for business sector and for public authorities to create whistleblowing structure, to create system how to receive reports, how to receive tips. Very short introduction to this legislation. We have three possibilities to protect a whistleblower. The first one, as it was mentioned yesterday by Tom, it's the most effective protection, but it is only dedicated to serious criminal offenses. So only for certain announcement of certain criminal offenses, this first type of protection is provided. And these criminal offenses are defined in three ways. The first one is that they are specified. There is corruption, offenses of public officials, public offenses related to public procurement or fraud with EU funds, or any other criminal offenses punishable by imprisonment of at least 3 years. And the last definition of this category is administrative fine in the amount of at least 50,000 euros. So in such case, whistleblower can ask prosecutor or administrative body, or in a proceeding before court, the judge to provide him protection, and based on this decision, he is deemed as a protected reporter, protected whistleblower, and all legal acts or decision made by employer has to be priorly approved by labor inspection. So, as I mentioned, this is the first area. The second area is related to this internal system of reporting. So all employees, all employers with at least 50 employees and public authorities are obliged to appoint organizational unit or a person responsible for agenda of whistleblowing. They are obliged to issue internal rules for receiving reports, for confidentiality and all other aspects of whistleblowing, and they are also obliged to create communication channel which is available 24 hours whole year. In this system, employees can report wrongdoings to a responsible person, and if there is retaliation, they are entitled to ask labor inspection for suspension of legal act, and this suspension is provided only for a very short period. It is only for 14 days, and in this period, employee has to file a petition for interim relief in court. So it means that finally court will decide about interim relief and the final decision. This second possibility of protection secures continuity of employment, but there is very strict period for filing this request for suspension. This period is only 7 days, and the last option for employee is possibility to sue so employer in court, the statute of limitation in this case is 3 years, and whole procedure is defined by anti-discrimination legislation. There is also possibility for this first category to receive reward, financial reward, but conditions for this reward are very complicated, especially the offender of wrongdoing has to be convicted, and then it is possible to apply for such reward, and the amount of this reward is 50 times minimum wage, so it is about 17,000 euros. So very briefly, structure of this legislation.
Thank you very much. Before we will definitely talk about the effect and what led to this law, but then first I will ask also Vladimir if he could describe how different is the law in Serbia and what are the most important aspects of it.
So the Serbian law was passed last November, and it became effective as of June 5th this year. The law is comprehensive as it covers both the public and private sectors and provides for court protection of whistleblowers. And whistleblowers are defined as a very broad group of people, including those who are employed full-time, part-time employees, even people applying for job positions, and also users of services of public institutions. Shareholders too, so it's a very wide range of those who can apply for protection if they're being retaliated against for any reason. So, as I said, it provides for court protection, and the deadlines for courts to decide are very short, and we've seen in the past few months in practice that the courts are generally applying this rule. So we had 2 cases of whistleblowers who turned to us for advice after they were being retaliated against for blowing the whistle on corruption. And well, I'm sorry to say that in the first instance, the higher court in Belgrade decided against the whistleblowers. But then the Court of Appeals upheld their appeals, and so they will be provided protection, that is, the termination of contract will be annulled. And the explanations of the Court of Appeals in both cases are very, very good, and this is the first time I've ever seen in Serbia that the courts have really taken up cases of ordinary people, and I don't know what the situation here is, but I feel like courts and judges in Serbia are generally more inclined towards protecting the government from the citizens than the citizens from the government. And that's why I was very much relieved and happy, because when I saw the decisions by the appeals court. Of course, having a law and having it implemented is only a step in full protection of whistleblowers. We still need a free press that will report on these cases, and of course institutions that will react upon tips from whistleblowers.
And is it possible to describe what tools are there for whistleblowers in the law?
Yes. The tools are the whistleblower can ask for temporary relief from court, and the court has 8 days to decide upon this. And as Tom said, there's no administrative relief, but when we were drafting the law, there were, I think, 3 options of who could provide this administrative relief, and it was the Anti-Corruption Agency, the Ombudsman, and the Labor Inspectorate. The working group spent a lot of time discussing this, and turns out that providing any legal remedy that would go through the Ombudsman's office would be breaking the constitution of Serbia, because the Ombudsman has no power over the private sector. And the Ombudsman cannot impose any decisions even on the public sector. Then the Anti-Corruption Agency, as its name states, only deals with cases of corruption. And the whistleblower protection law in Serbia is comprehensive in that it covers not only corruption, but any abuse of office, any procedural breaks in law, and even damage to the environment and wildlife. So it's very comprehensive, and the Anti-Corruption Agency would not be able to protect people who were reporting other things aside from corruption, and also the Anti-Corruption Agency does not cover the private sector. The third solution, the Labor Inspectorate, which I thought would be very good. Well, it turns out, and we've had a recent case from our practice as Pištaljka, that one whistleblower, he's a lecturer at Belgrade University, and he was fired after he blew the whistle on corruption at the university. And then he asked for assistance from the Labor Inspectorate, and the Labor Inspector issued not one but 3 decisions against the university, and the dean of this faculty doesn't want to implement the decisions by the Labor Inspectorate, and there's no way that the Labor Inspectorate can force the decision upon him. It has to be the court. And now this whistleblower has applied for protection using the whistleblower protection law.
So, so you end up with this solution, and just very briefly, what is the protection to the whistleblower? What protection can the court offer?
So the court can annul any decision that's seen as retaliation against the whistleblower, and the most important thing, there is no good faith clause. So the court does not go into the motives of whistleblowers, and the court is allowed to annul any decision and give the whistleblower back their rights, and then it goes through another court procedure, like an employment law procedure, but the whistleblower is reinstated until the court decides upon this case.
Mm-hmm. We will maybe get into more details later, but I would like to ask Anita, because if I understand well, there is some kind of legal protection or a law, but it is not really working or not being applied. So what is the situation now in Hungary?
Thank you again. Yes, the situation in Hungary looks like basically the following. We try to enact a Whistleblower Protection Act in 2009. That was our first try, but it wouldn't be promulgated by the President of Hungary, and it contained very straightforward measures and at least tries in a way to protect whistleblowers. It was supposed to be comprehensive legislative acts protecting whistleblowers and setting down a legal framework for providing aid for them and financial aid and protecting their closely relatives, and establishing also at the same time Public Interest Protection Office that was supposed to be a real independent body, an oversight body, but it was the concept was harshly criticized by NGOs, and because there was a chance that it wasn't turn out to be a real independent body. So Later, the government stepped back, and it didn't enter into force, this bill. So this was our first try on drafting a whistleblower legislative act. And later in 2013, Parliament adopted a new act on complaints and public interest disclosures. So they are regulating together complaints and whistleblowing reports, but they are not calling them whistleblowing reports in the law on the level of public declarations.
How do they call them?
Just the public interest disclosures, so it's not the same actually. it's between a little bit difference, but still it means the same phenomenon, but on the level of political vocabulary they do not like to use that term so well. And actually, there is a distinction between complaints and whistleblowing reports, and on the level of normative definitions, they are saying that every kind of malfeasance and misconduct that could be excavated in order to save the interest of the community can be considered as whistleblowing. And complaints would be and allowed to be filed only in case of violation of personal interest and individual interests or rights. Our system has several challenges right now, because there was supposed to be an implementing decree issued by the Ministry of Justice that hadn't came alive until now, that was supposed to regulate the financial aid provided to the whistleblowers in case they are, I don't know, dismissed from their jobs or whether they're threatened or when close relatives or not so close relatives of them are threatened. So basically the actual practical side of the law is not working because there is no implementing decree issued by the Ministry of Justice and Minister of Justice. Otherwise, just with keywords, our system is supposed to tend towards this anti-retaliation model with a few components of structural models, because there is a new institution enacted in the process protecting whistleblowers. It's the Office of the Ombudsman, and this office can handle and maintain and operate an electronic receiver system for reports filed from whistleblowers, and they should take care of preserving anonymity in a way, but they are not allowed to conduct substantive investigations. So it's just a formal and technical investigation, and rather playing a role of a transmitter and a transfer, but they should provide and guarantee that this report filed from a whistleblower and received by this electronic whistleblower system to be transferred to the competent body that should investigate these reports. Actually, whistleblowers could turn anonymously to this Office of the Ombudsman and to the Ombudsman himself too, but lately there was a new change of law together and parallel with Hungarian freedom of information legislation, and that showed the governmental and the legislative will that they try to restrict eligibility of anonymity filed reports. So you cannot be sure if you're a whistleblower or a public data requester anymore that you file a request or a report anonymously that could be really initiated investigations upon. So basically the law just says on the text and on the wording level that they not investigate this kind of requests. It also doesn't state that they are not allowed to do that, so it's up to the decision of the of the competent body whether or not it would conduct and initiate an investigation. But we can be almost pretty sure about the outcome of this decision, that it would be disadvantageous for public data requesters and also whistleblowers. So that's one thing about one of the biggest issues is this anonymity that is not prevailing in practice. And the other shortcoming and the bottleneck of our regulation is, like I mentioned, that no protection is guaranteed for whistleblowers when they try to turn to the public directly. So they can be sued for defamation, they can be sued for breaches of confidentiality, they can be dismissed from their positions, so it's not allowed to go directly to the media. After every kind of legal remedies and every kind of failed attempt to get investigated, their report maybe, that's as a last resort, can they turn to that, but legal provisions do not allow directly to turn to public in Hungary. And other very interesting thing that every kind of, so that's why it's mostly anti-retaliation system and model, because every kind of action and measures taken against the whistleblowers could be considered as detrimental unless it has been proven that he or she, the whistleblower, was conducting some kind of crime or doing that from malfeasance and had committed some kind of misconduct. But it's very interesting that what the law considers to be detrimental, because initiating a criminal procedure against the whistleblower only just to investigate and establish whether a crime has or hasn't been committed by it, that wouldn't be considered as detrimental. So criminal procedures can go on a parallel while they are providing this kind of legal protection and alleged legal protection for whistleblowers. And one last thing. And about confidentiality, the law, the current existing and law in force, doesn't get a waiver for whistleblowers to release confidentiality information. So they not release the whistleblower to publish confidential information, and it's of course doing it in a very exaggerated way, because every time when whistleblower files a report to the competent body that's supposed to entitled to investigate these reports, they are not allowed to do that, only just using by this electronic system like I was talking about, because only the office of the Ombudsman can take care of that, handling this kind of confidential information. If a whistleblower files and circumvents this electronic system, files a report directly to the competent body to be even subject to these investigations, and if it contains confidential information, the whistleblower can be sued for breaching confidential information, even if he or she thought that lied to just get investigated this report. So it's really a far-fetched try and a very exaggerated and extrapolated interpretation of breaching of confidentiality, and that's why the Ministry of Justice issued an interpretation to the law that the safest choice of a whistleblower to file a report should only be this electronic system maintained by the Office of the Ombudsman, because they are entitled to handle confidential information, but otherwise they could be sued and fined. Okay.
So that's a pretty
many
harsh critique of, but with this law not being enforced because of the lack of the implementing act, is there any specific protection for the whistleblowers now?
Yes, actually, this is in Hungarian legal system, without an implementing decree, you can actually, the law can exist constantly. So on the level of the legislative act, the bill that has passed the parliament and was promulgated properly by, in the official gazette of Hungary and signed by the president of Hungary, so it's in force. But there are lacking of detailed regulations how this really should be done and could be done, and this lack of implementing decree only means that we are not having this kind of regulative guidance how to do that on the everyday life. Otherwise, this legislative act is enforced, and it could be, of course, behavior based upon that, and the investigations conducted about that. So that just means lack of information, and that's why every competent body and the ombudsman itself should decide how they'd like to conduct these investigations, because there are a lot of missing details. So that's the disadvantages having a missing implemental decree, but that not has effect on the real effect of the law.
So has it been applied to any cases?
It entered into force on the 1st of January 2014. And ever since, I'm not aware of the fact that it has been really used, because one of the biggest Hungarian whistleblowing scandal took place in the autumn of 2013, and actually the whistleblower was prosecuted for several charges, but the court delivered a decision that he wasn't guilty, but still, I'm not sure that there were famous cases about that that the law had been really applied. No. So not yet.
Okay, Anna, you are author of a blueprint of a law that should protect whistleblowers in Poland. What principles does it follow, and was it inspired by any of these countries we have discussed?
Hello everybody. Before I answer the question, I would like to thank the organizers for organizing this event and for having me here. So the document I prepared, actually this is not actual blueprint for law, but it's like the assumptions for law, and also a brief analysis of legislations in a few countries. And those assumptions for our law embrace the works which we did, I mean the Battery Foundation, for which I work in Poland, in the field of whistleblowing. And actually these are two researchers. The one research which the aim of which was to check whether labor code really works in the courtroom, and what is the efficiency of labor law in real life, not only on the paper. And we went to the court judges, to the labor codes, and asked the judges, how would you implement labor code provisions to the very specific case, like the case of whistleblower? And interestingly, the first answer to the question, general question, do you think we have enough legislation in this field? The answer was, yes, we have enough protection. But later on, when we asked specific questions, do you think that discrimination provisions could be applied in this particular case? The answer was not that clear. The answers were like, well, I'm not sure, probably not. So this research showed that even if we have labor legislation and labor code, it's not efficient in the context of whistleblowing cases. So this is one research which we showed in our assumptions for whistleblowing legislation in Poland. And the second one, the approach of regular people, of Polish people. We made the research which showed that on the one hand, the respondents declared that they would make a disclosure if they happen to notice some irregularities or wrongdoing. But on the other hand, when you ask them more subconscious questions, you see that these declarations may not be really true, that these are declarations only in the sphere of ethics and probably self-esteem, because then from other questions you see that Polish people would expect, first of all, ostracism in the work environment, various kinds of, like very light ones and also very strong ones. The other thing is that Polish respondents would expect some kind of negative reaction from the part of the employer. So when you combine those declarations together with the other responses to other questions, you see that there is contradiction between the two. So the conclusion you can draw is that if you don't have legal conditions, and also you don't have social conditions, because social conditions are rather reluctant and not friendly, unfriendly, then you may not expect that people will blow the whistle on anything. And we also compared legislations from a few countries. Now I see, and I totally agree, that it is very important to see how the legislations really work, and what are the shortcomings, just to try avoid the mistakes.
And what is the main tool you are considering, or that you like, either from the protection in neighboring countries or in other ones? What is the one you would bet the most on?
Probably I would try to pick up the solutions which construe the best standards, the one that we talked about yesterday. First thing, the most important from my perspective, is that we need to have the legal concept of whistleblowing and whistleblower written into the law, because if you don't have such concept, and this is also said by the judges, you have no instrument to refer to, you have no basis. If there is no such concept and you are a whistleblower, you don't really know how to construe your claim, how to build your claim. And also the judge has the difficulty to give the verdict. I know the case was told me by a judge who said that I had a whistleblower, and I gave a positive verdict toward the whistleblower, and I said in the justification of the verdict, she's a whistleblower and we should protect whistleblowers because they act in the public interest. But the case went to the Court of Appeal, and the Court of Appeal said, what is whistleblowing? We don't have such concept in our law. So you see, this is very important to have the concept, and this is the starting point. And of course, very important thing is this wide personal scope of the act. In Poland, we have a high number of people who are active in terms of their professional life, but they work based on so-called flexible relationships, which means that they can be dismissed, and the employer is not obliged to give the reason for their dismissal. If there is no reason, the court is not even allowed to ask about the reasons. So if I'm a whistleblower and I work based on civil contract, and I go to the court and I say, I'm a whistleblower, I did something good for the public interest, the court would say, I'm very sorry, but I'm not going to check this thesis, because I'm not even allowed to. So I think that from my perspective, these two things would be the most important.
Thank you. In Czech Republic, we do not have a standalone law or legal protection for whistleblowers. However, there is something hidden in the new Civil Servants Code. Can you tell us, Lenka, what you think about it and what is in the plans?
Well, actually now I'm glad that we have at least this so I can speak about something. But otherwise, when I'm speaking seriously, I mean the content of the new regulation, which implies to the public servants, does not really provide the real protection. I think that even the creators of the new regulation were aware of this, but as it's not an act and it's only the form of regulation, the borders in which they had to compose the new rules were pretty tiny. So the new regulation just deals with the organizational issues of reporting. As I said, it applies just for the public servants, and it says just how you can report, just where and to whom. But the problem is that the receiver of the reports is the person inside the offices. So there is unfortunately no independency of this person. I think that you can see it the most clearly on the example of for example, Office of Government, where is the investigator, which is that new concept, and this investigator is responsible to investigate the minister he's working under. So this situation just shows that that the regulation was really just attempt to provide some serious protection, and now I think that there will be needed the support for the new investigators to explain them by some methodology how to really apply it, because even in the regulation there are no powers they have. So I feel a bit like loser here in the panel, but when it comes to the legal framework, but it's true that we are at the start on a long way, so there are some approaches, and even this regulation is the experience we can use while composing the comprehensive law.
I would like to ask Pavel, if I understand well from a question submitted, do you have such investigators in Slovakia?
I'm sorry?
You have such receivers of whistleblowers reports in Slovakia, such as Lenka mentioned, or not? Because there is a question asking whether you have any methodology or for those who investigate whistleblowers cases. And I don't think these are, they mean criminal investigators, I think some civil investigators.
You mean as transparency, or you mean...
No, in the law.
In the law, no, there is no specific provision on methodology, although Labor Inspection issued methodology on dealing with reports, but it's a very basic document, 3 pages, and it describes only formalistic criteria which has to be met.
But as Transparency International Slovakia, you do have some kind of methodology for them?
We don't do investigation. But well, let me use this opportunity to share you some fresh data which we have from evaluating or contacting labor inspection. As I mentioned, they are responsible for implementation of this agenda. So we send them a request for information, and from this request we know that there were 6 cases, some from effectiveness from 1st January this year, and they were not provided with increase of number of employers which are in labor inspection, and there is no increase of funds, of financial sources for labor inspection. Therefore, we were curious how does it work, and during July and August we contacted as whistleblowers. We created 8 cases and pretended to be whistleblowers, and we were waiting for answers. I can tell you that they are horrible because within this period, 7 days, as I mentioned, this period is crucial for keeping continuity of employment. Only one inspectorate was able to answer us our questions. In 6 cases, it was after this period, and in 2 cases, we didn't receive any response. Only in three cases, inspectorates were able to recognize even legislation, because we, in our examples, we didn't identify legislation. So as we see, there was a demand from politicians or formal declaration that we want to have legislation, but no real instruments were provided for labor inspections, which is responsible for its implementation. Maybe 2 sentences about private sector. How does it look? It could be also interesting. They are really afraid of fine, which can be imposed by labor inspectorate. This fine is up to 20,000 euros, but they don't understand that they are also victims in these cases, and they should implement whistleblowing schemes properly. One ridiculous example is that one company created this communication channel and created email snitch at companyname.sk. So they send message to employees how they understand the situation.
Maybe one brief question from the audience. Has this legal protection changed or influenced anyhow also how people or how general public views whistleblowers in Slovakia?
Not yet, and we cannot expect in such short time any influence. As I had chance to speak to police, to people which have experience with other instruments which were adopted in criminal code, they expect at least 5-6 years for implementation. It's necessary to wait for first court cases, and then we can have influence also on the public.
Mm-hmm. And a very similar question to Vladimir, but also I was wondering what helped you in pushing through this legal protection. Was there some crucial case or player who did the job?
This was a combination of factors. Just briefly, I should mention that the Serbian law on civil servants calls for every civil servant to report any wrongdoing, and even threatens those who don't report with jail. Yet the law on civil servants never had any provisions for protecting these people or declaring procedure on how to report this. So it was a combination of factors, the fact that there were some provisions for whistleblowing in different laws and regulations in Serbia, and that there were a number of cases of retaliation against whistleblowers, prominent whistleblowers, and we wrote about these cases, and in some cases we managed to have them reinstated after we published articles. Retaliation stopped, and they went back to their old jobs. But the thing is, there was also an initiative from the European Commission to have this law, and Serbia is negotiating EU accession, and so the EU still has some leverage over the political situation in Serbia. And also another important factor was that there was a change in government 3 years ago, and the new government wanted to show that that their hands are clean and that they're not corrupt as the old government was. And so they needed to have a coup, so to say, and they saw whistleblower protection law as a chance to convince the public in general that they were serious in dealing with corruption. So it was a combination of factors, and our reporting was also instrumental in this, and the fact that we organized the first ever meeting between a justice minister and whistleblowers, and that the justice minister during this meeting promised that a comprehensive law would be adopted.
And is there an effect on general public due to this legal protection?
Well, just this morning I read a piece of news from Belgrade that a whistleblower went public, and he said that he has evidence of a public company director, manager, having plagiarized his doctorate, his PhD, and the whistleblower says he insists that the institutions who are in charge, who should investigate this, must act according to the whistleblower protection law, and this law has very short deadlines for investigations. It says it should be started in 15 days after the reception of a report, and that the whistleblower should be informed about all actions taken, and that a whistleblower can even take part in some of the investigations. So it will be interesting, because this is getting a lot of attention in Serbia, this piece of news, and people are starting to realize that this law is one of the few laws in the country that actually serves the public and citizens. So I think we're about to see a real change.
Because we have only 5 minutes left, I would ask you all if you can very briefly say what would be your recommendation, but specifically for the region we are talking about. If there is something, because many times the objection to the general recommendations or principles are that we are somehow specific here. So is there something that should be stressed out, something that should be underlined for your country that is crucial so the legal protection works? Maybe Anna, if I can ask you.
I don't want to go into technical details because it was already said so much about particular provisions, but I would say that it was also said that we should look into our history and the cultural context. And in Poland, I often hear that whistleblowing law is not for Poland because of its history, because whistleblowers will be treated as traitors and as snitches and as confidants as well. So I would say, and maybe this could be my recommendation, that we should look at the potential of whistleblowing law. And I see the potential that I totally agree with Richard, who said that the law can change social attitude and can reverse the values and show the real values. Apart from the fact that I still believe that whistleblowing law, specific whistleblowing law, would give us some tools, concrete tools to build up protection for a whistleblower. it could also change the culture and the perception of what is the public interest and also what is our role in protecting public interest.
And exactly from these reasons, which mentioned Anna, it's, in my opinion, necessary to have standalone legislation, to have one act. And I don't agree with Mr. Moravec, what he said yesterday, that there are possibilities, there are ways in legal system. Yeah, of course, in Slovakia we had also possibilities to defend employee, but it is impossible to persuade all judges and to persuade employers about necessity to implement or to defend employees in this way. Therefore, there is advantage if we have new legislation, we have new arguments, we have new instruments how to deal with this agenda, and yeah.
Thank you.
I'd like to a bit disagree with what you said, because only a law itself cannot change people's mindset about things. For example, we share this common history, like in Hungary, whistleblowers could be considered as snitches, and our law, of course, covers both public and private sector too, and they are really not fond of these people who are just try to blow the whistle and consider to be snitches. But recently there was this big scandal I was briefly mentioned, 2013, that showed that, for example, a former tax inspector working at the National Custom and Tax Authority and Administration can really change and shape people's mind about that, because very shortly it was a VAT fraud and then so-called very sophisticated system of chaining invoices, and this tax inspector excavated very much detail about this chain invoices, and he got fired. He got sued for defamation, and he was prosecuted with breach of confidentiality and publishing confidential information. But still, he collected this data and went public with that. And finally, this year in the summer, the chief prosecutor of Hungary admitted that there are investigations going on within the rank of higher tax officials based upon this fact that this whistleblower collected. So basically that was the main part, that he said that from the upper rank of this tax authority, higher rank officials try to prohibit going investigated. This, of course, that can happen everywhere, but still. And people started to believe that this could be a good thing, and if we would have enforced back then this regulation, then it might have turned otherwise. So he was, of course, declared by the court not guilty, but he lost his job and were forced to live under very bad financial circumstances, which would be my other recommendation for the Hungarian legislator, that finally they should really provide legal and financial aid for whistleblowers, because otherwise it cannot happen.
Thank you.
So, for me, I totally share the idea about having the legal concept, which I see as important also, because I can't imagine to protect, especially against retaliation, through the non-legislative measures. So that's the first thing. But the legal concept should be accompanied with the public awareness campaign. But I'm raising it because I think that it's already starting from the side of NGOs. But what I think is that the public awareness has to be more done by the state authorities, so the whistleblowers know that they are supported and that they are seen as an important in protecting the public interest, and that it has a value for the state, because then I think even we have a good act or a good comprehensive legal framework without doing the public debate and supported, the enforcement will be very low. Which we can see at other different legislation. If people don't know why these rules are applying, then they are not going to follow them. Third thing is that as we are at the start of composing comprehensive legislation, I think that it's very important to have at the table all the relevant stakeholders, including public and private sector representatives, also the whistleblowers, also the representative of police or public attorneys, and to let discuss all of them, because it's not possible without the experience to have just public servants to discuss the issue, and also the NGOs, because we have all the different experience. And after, that's the last point, we can talk about the concrete tools which should be in the law, and for example the temporary relief which is in Serbia.
Thank you.
I will just briefly say that even the best law will not do any good without a free press and functioning institutions that will investigate reports by whistleblowers.
Okay, thank you very much. If there is nothing nothing of a great importance that I have forgotten to ask you, we have to finish this panel discussion. I see a light of hope in the fact that the laws are getting closer and closer to Czech Republic, so we might get infected by that in the near future. I thank you very much for your attention, and I thank all the panelists that came here and shared their experience.
Thank you.